Everyone from beautiful Toronto, Canada. It is an incredible and humbling honor to be part of this. I want to cast you back 44 years ago when a much younger me was sitting down or just around this time of year to write my very first law exam in first year. I'm totally blind. I'm sitting in front of this ancient device called a typewriter. I'm typing madly for about 20 minutes on my criminal law exam when I realized that the ribbon had broken. What that means, for those of you who don't know what typewriters are or how they work, it meant that I had been typing and the pages I was producing were beautiful but blank. Nothing had been transcribed. This is not the way you want to start your career of writing law exams. I was able, thankfully, to get a new ribbon installed. Thankfully, I found out after only 20 minutes, and I wrote like crazy, caught up, and got the exam done, and it turned out to be an A, which led me to think that the more of my ribbons break, maybe the better I'll do. The challenges that I have faced as a blind person practicing law after completing law school for 33 years before I retired from working for the Ontario government in the areas of civil and then constitutional and then criminal appeal law, the way I've tackled them have evolved very much like the way public transit has evolved from when our great-grandparents used a horse and carriage to get around, to the way in Star Trek they travel at warp speed, faster than the speed of light. Somebody's typing and they're not muted, and I just want to ask if they might want to mute themselves just so that that doesn't affect people. Thanks very much. In any event, I don't want to talk about my specific practice strategies because they evolved so often with technology, from human being readers to towards the end preparing a murder case when I was at the dentist, and I wanted to get every last minute of time in preparing, and simply while the dentist was working in my mouth, having earphones, and my iPhone is playing a murder trial transcript to me. From being able to have to sit up at nights transcribing notes into Braille for hours, to being able to walk in with a laptop with everything written down on it so that I just put an earphone in my ear. The transformation was spectacular in my career. What I'd like to do instead is to focus you just for a few minutes on what I've been doing since I retired and what I was doing before I retired, all part-time, now it's full-time, in a volunteer capacity, because I've taken those skills I used in the courtroom and transformed into a volunteer practice as a community organizer and community advocate on disability accessibility issues here in Ontario and in Canada. I'm not acting as counsel. I'm not, in fact, acting as a lawyer. I'm a community, I lead a coalition, the Accessibility for Ontarians with Disabilities Act Alliance. But I've actually been finding that in this lay role, I'm taking all the skills that I learned as a lawyer, the skills in writing, in organizing, in formulating strategy, how to frame an argument orally, indeed even how to question people at a meeting, that I learned in the courtroom. And to that extent, I had to also draw on the skills that as a blind person I had to learn to use in a courtroom, how to size up how people are reacting when I can't see their faces. I've had the privilege, just to take you in my short time on a quick tour, I began 40 years ago this fall, when Canada's Constitution did not then include a Charter of Rights. And our Parliament was debating whether to include one. It was proposed to include an equality rights clause, but it wasn't going to include disability. A number of us, including me as a young law student, had the opportunity to appear before our Parliament. I did it 40 years ago plus 10 days, December 12th in 1980, and the video of that is now up on YouTube. I'm told I look different because I had hair back then. To argue, and we were all collectively successful in winning the Constitution, the disability amendment to our Charter of Rights. I was able over a decade later to take part in and then eventually lead a decade-long campaign to win the enactment of our counterpart to the Americans with Disabilities Act, the Accessibility for Ontarians with Disabilities Act, and I now lead the coalition called the AODA Alliance that campaigns to get it effectively implemented. The blog will include key links to give you more background information, but if you want to learn about what we've been up to and see our strategies, you can go to aodaalliance.org. Now I'm involved very actively. Since then, I've been involved with many others in campaigning to win last year the successful enactment of the Accessible Canada Act, our federal counterpart to our provincial legislation. But what the message I really want to bring home to you is, just as over my career as a practicing lawyer, I evolved my strategies from typewriters to iPhones, from human being readers to screen readers. And just as the challenges changed from print documents that were inaccessible to PDFs that are inaccessible, and having to learn to react to them, I've also learned how to harness different strategies in my community organizing. Let me just give you a few examples. One of the things you learn as a lawyer in a courtroom is how to frame your argument, your case's position, in a way that will most compellingly express your case and most persuasively disarm your opponent. We've done that in our accessibility movement. The old way of talking about these things was discrimination, and I agree that inaccessibility is discrimination. We instead talk about barriers and the obligation to achieve a barrier-free society. The beauty of the word barrier is it doesn't alienate the left or the right. The left thinks barriers are unjust. The right thinks they're inefficient. They all hate barriers. Even businesses hate them because they impede them from getting access to clients and customers. We learn to not talk about people with disabilities as a minority. I have a kind of a blind gig or trick I do when I'm speaking to audiences. I ask people I say, I want to know if you're part of our movement. Raise your hand if you don't have a disability now, and if you know you'll never get one in the rest of your life. I then turn my head as if I'm looking around the room, and I go, I don't see any hands. And everybody laughs or chuckles because it's kind of a blind joke. But I then declare, we are the minority of everyone. By redefining disability inclusion as the minority of everyone, we've now turned ourselves from a minority, we can't afford you right now, to the majority, to everyone, and therefore strengthen our case. We've also learned how to use evolving and different technologies. If you want to get our updates to learn our strategies, you either go to our website or you write me at aodafeedback@gmail.com. and just say, sign me up, aodafeedback@gmail.com, or follow me on Twitter at David Lepofsky. Lepofsky is Lepofsky. But what we've learned is to go beyond even those traditional things. We use Twitter very actively, so much so that I've had public servants call me and say, can you please not tweet about this Friday afternoon because we want to go home for the weekend. I consider that the supreme compliment, or a politician who kind of groans and says, you folks sure tweet at us a lot, with a bit of an edge in their voice, but also a pat on the shoulder with a keep it up. But the other thing that we've learned is that we keep reinventing our strategies. I'm just going to give you one or two. One of the things, we wanted to point out the fact that buildings are repeatedly still designed to be inaccessible. And that's, even though the myth is that we only used to do that in the old days before we knew better, but now we know better. We found that architects are doing a worse job now than they used to before. And how do you point that out? Well, you can write briefs and you can make speeches. We did that. But I decided one day to take my iPhone into a building that was emblematic of how this is bad, a brand new university building. I got a friend to help me, and we shot a video. It's up on YouTube. It's had thousands of views. It's gotten media coverage. It's been used in different countries, and it's being used to train architects. It depicts the barriers in a building which turns out to have been awarded architectural awards, and it's a blind guy narrating it. I had sighted assistants, of course, putting this thing together, God knows, but coming up with the use of a free site like YouTube and the creation of a video, It borrowed on the same skills I use when I wrote a brief, or what we in Canada call a factum for court. In fact, I worked on the text of our script, checking it the way I check the facts when I would appear in the Court of Appeal of the Supreme Court of Canada in a brief that I'm writing. And bringing this up to the most recent, and with this I'll turn to my conclusion, but the most recent cause we've been very actively involved in is battling the barriers that people with disabilities, the additional hardships during the COVID crisis. And so one of the new resources that we're using is I've been able to get a number of lectures I've given posted online, captioned and available for anyone to see anywhere around the world. If you just search on my name on YouTube, or you go to our website, you'll see links to all of these, including a lecture just posted a few days ago on our battle during COVID. But one of the battles that we've been facing is the fact that with hospitals being overwhelmed, and this is an issue in your countries as well as ours, with hospitals being overrun with COVID, there's a risk that there won't be enough critical care beds, that there may be triage or rationing of life-saving medical care. And in my country, that medical care is guaranteed. It's insured through public health insurance. Well, how's it going to be done? We have a serious documented fear that it could be based on discrimination based on a patient's disability in some circumstances. So a bunch of us did some advocacy on this. We've made some progress, but not enough. But you can go online and see a lecture I gave at my law school documenting this history that we're now tweeting to journalists and politicians. And you can also see a presentation I made to the government's own advisors on what on bioethics, on what the standard should be, so they can know what our pitch is. This is all available through our website at aodaalliance.org/COVID. Let me conclude with an ask for anyone watching, including in case anyone from yesterday's program is watching. I'm now a part-time professor, visiting professor at the Osgoode Hall Law School here in Toronto. And one of my jobs is to write a report for my faculty on ways to better include disability rights in the curriculum of the law school. Both what should be included and what strategy is most likely to get it actually included in what's taught in the classroom. I welcome any of you, the ideas from any of you. Write me at aodafeedback@gmail.com, aodafeedback@gmail.com, and I encourage you to let me know your ideas. The blog will include links to various of the resources, the videos that I've talked about during this talk. Let me conclude by paraphrasing what I said to the Parliament of Canada 40 years ago plus 10 days, when I was arguing with others to get disability included into our Charter of Rights. A number of us combined to win that. I said in conclusion there, and I say today, that it is a cliche or an aphorism that justice is blind. And yet, for us, it's important not only that justice have the opportunity to experience blindness, but that blind people and all people with disabilities equally have the opportunity to experience justice. Thank you very much for including me, and I look forward to hearing my fellow panelists and to your questions.